welcome to our webinar. My name is Anthony van der Hoek. I'm going to be your host this morning, and we're going to be unpacking South Africa's landmark Constitutional Court ruling, which was handed down on the 3rd of October 2025 in the case of Van Wyk and others versus the Minister of Employment and Labour. So the court found that aspects of the Basic Conditions of Employment Act and UIF Act as unconstitutional for unfairly discriminating against, or rather between, birth mothers, fathers, adoptive and commissioning parents, and also set an interim shared parental leave regime while Parliament has 36 months to amend the laws. So today we're going to look at how this all arose. We're going to look at practical steps of implementation. And if I may introduce our panel, we have Charity Bayi, who is a lawyer and specialist in industrial relations with BDO HR Advisory. We've got Sue Naidu, who's an HR specialist with BDO HR and Advisory. And we've got Lorraine van der Westhuizen, who's a commercial lawyer, who's also a director of StatuCorp, which is part of the BDO South Africa group. So to start off, let's start with you, Charity. Give us a bit of background as to how and what sparked this debate.
Thank you very much, Anthony. I'm just trying to, okay, here we go. Thank you very much, Anthony, and good morning, everyone. I think this is really a good place to start because this change didn't just come out of nowhere. You gave a brief background of what happened, where the Van Wyk family made a conscious decision that the father would be the primary caregiver after the birth of their child. And he basically asked for an extended leave that is similar to that of maternity leave. And at that point, the law simply didn't allow for it. So that's where the Constitutional Court stepped in. And you did touch on the fact that they did declare the Basic Condition of Employment Act, the legislation, as unfairly differentiating between parents. And it's also important to note that the invalidity, like you mentioned, has been suspended for 36 months to give Parliament time to fix the legislation. But it didn't just, the Constitutional Court didn't just leave a vacuum. So on the 3rd of October 2025, what it did is it introduced an interim measure that would apply immediately. So now that means where we stand currently is there is now a universal parental law pool of 4 months and 10 days, which applies to all parents, whether it's birthing parents, biological, adoptive, commissioning. That leave can be shared between parents in any way that they choose, and they can divide it into any ratio. So, and if both parents are employed and can't agree to how they will divide the leave, it will need to be split as equally as possible. And if it's just the single parent that is employed, then they are entitled to the full 4 months. And another important point, Anthony, that I think I need to make is that previously the Basic Condition of Employment limited adoption leave to cases where the child is under 2 years. So that has also fallen away, and the court has recognized that caregiving is not caregiving responsibilities do not disappear because a child is older, or and it recognizes that adoptive families should not be treated differently based on the child's age. And I think I'd like to also add to that if an employer, this is important for employers, if they historically offered paid maternity leave only to birthing mothers, the benefit now sits in a much more equalized parental leave environment. And I'll just put in one last point. to just not take too much of the time. When you zoom out a bit on this, you also see that this judgment also sits within a global move towards an inclusive caregiving. So internationally, we're seeing currently a shift away from the idea that caregiving is a woman's work, and we're now moving into recognizing different family structures. So that's where we currently stand at the moment.
Sure, Charity. Yeah, it certainly seems to have thrown the proverbial cat amongst the pigeons. Obviously, there's going to be a lot of challenges. And I think the complexity is what do we do next? Because the laws are not there to govern us specifically. So I'm going to move across to Sue. And Sue, I'm going to ask you, as an HR implementer of policies, what impact has this got on HR day to day?
Hi, Anthony. Thank you for the question. Actually, the impact is great because it starts with the update of the contracts, policies, handbooks, all of that. And then it flows into when a woman goes on maternity leave. I know it's gone into parental leave, but when a woman goes into maternity leave, what we have is a maternity pack that we present to the lady to update in terms of when she goes on maternity leave, when she's deciding to come back. Now, those packs need to now be made gender neutral. So all of the documentation now become gender neutral. One of the things that we have added as soon as the act has come into effect, because it's effective immediately, is that we've now added in a disclosure. The disclosure that we have added in would now, the parents get to alert the employer as to what the split is going to be between the husband and the wife. Probably the wife is a stay-at-home mom, and then the husband has full access to the 4 months and the 10 days. But there are situations where it is a 50-50 split, and the only way of us getting information about that as an employer so that we can plan appropriately is to have the disclosure in there. And over and above that disclosure, we do have a couple of documents that we used to ask previously that we still do ask for. One of those documents is the medical certificate for due date. So that would give, again, an idea of when, because we don't really know when baby decides to surprise us. And then, so also following that, we would need a birth certificate as well. Now, it gets even more serious when HR now has the role of identifying critical roles in the company, because what we need to now do is plan for cross-training. We need to plan for temporary staff. We need to plan also trainings in terms of how are we going to train managers? How are we going to train employees in terms of their rights? And it flows a little bit deeper. So from an HR perspective, HR is responsible for the business in terms of how assisting business with operational flow. So where HR produces HR metrics to the business, one of the metrics we do provide is where HR looks at how many employees in your business are of childbearing age. Previously, we only used females. Now we've got to say, oh, well, now we've got to include males into that. And when we include males into that, also remember, males can go on parental leave more than once. So this type of a statistic for the finance department, very important. It's also one of the reasons why we're having the seminar now, which is just before most of the financial year ends for the companies, so that when the companies are going forward, they're going to be forecasting, they're going to be budgeting. They're now going to know from an HR metrics point of view what variables to include in those types of decisions that they are making going forward. There's a lot of the companies that, although maternity leave is unpaid and parental leave, what happens is companies are giving discretionary benefits. So, for example, if a company is giving 100% benefit, they now have to extend this to the males as well. And this can become quite expensive. Or some of the companies, they pay you the difference. If UIF pays you an amount, they pay you the difference. So these companies now, they have to relook at all of the discretionary benefits that they provide. Is it affordable? Because they still have to consider, we've got to now employ staff. We've got to train staff. So there's a lot of factors that come in, the link between HR and finance. HR also feeds into payroll. So what are we going to do from a payroll perspective? From a payroll perspective, it's systems readiness. Yes, UIF systems are not ready, but payroll readiness, that's on the cards, whether we like it or not. So in terms of payroll, there's going to be leave codes. It's going to go from maternity, it's going to go to parental. The one thing I'd like to mention is that we actually use a payroll code, which is on our UIF form. And that is code PL, which is for parental leave. We are still using that code until UIF changes it. So that at least now we know when a male goes to apply for that parental leave, he will get the 10 days for now. For now, he'll definitely get the 10 days. In terms of what do we expect of employees, we expect employees to at least tell us 4 weeks before they go on parental leave. And the reason for that is it helps us with operational flow. It helps us accommodate the business and accommodate the employee in good time. So there is a lot of changes that is happening, but what we need to do is just make sure that everybody is trained as to what is required of them and how we all can help each other ensure operational flow is 100% and employees get what they are entitled to.
So, Sue, I mean, we obviously established as a legal framework in terms of the Constitutional Court ruling, and my understanding is that that can't be reversed. It's the top court of the land. So if we talk practically now, implementation, and you kind of referred to the policies of the company, does the company have, I mean, obviously we've got no laws which specifically guide us. Does the employer have discretion to determine its policy?
Yes. So in terms of the law and policies, basically policies have to have the minimum, what is structured by law. And if it decides to go above what is provided in the law, that is allowed. It only can't go below the provision of the law. And most of the companies that we have encountered with the HR outsourcing at BDO is where the companies are now coming to us and they're like, well, Sue, we need to speak because with this new change, we have a situation. We already have a policy that's giving 100% benefit on maternity. And we've got 70% males, we've got 30% females, still keeping in mind that males can go more than once within the year. So that means we have to rethink. Are we going to, it's well within their rights, they can't afford it, to now adjust the policy, obviously with consultation, they can do that. So it's bringing up a lot of, I think, okay, just to mention on a case study, the company that we did consult with, they were using 100% benefit for maternity to attract females into the organization. And unfortunately, they're going to have to reconsider that because their split is 70-30. So these are the things that employees are considering. Yes, they're able to change their policies, but just keep the minimum standard of what's required by law. Okay.
So, I mean, it's obviously going to create quite a lot of effort to make sure that all aspects are covered. I mean, from what you're saying, and that kind of resonates with me being an accountant, is that there are financial implications. So I'm going to move to Lorraine, and Lorraine, obviously in this period when I'm not saying there's confusion, but there's nothing specific, and there's a lot of leeway in terms of developing policy. There could be conflict. How do you see this playing out in the labor law environment?
Yes, thank you, Anthony. The judgment that for Parliament 3 is to change legislation to comply with the order, but there are certain elements that will be effective immediately, and companies will have to avail themselves of those and change their policies and their treatment of such accordingly. I see from some of the questions it already shows where the challenges are going to come in, because it's going to be in the practical application of this, because it's one thing to have an ideological sort of motive behind providing for inclusiveness. It's a whole different thing to practically apply. There are practical challenges to this. It's like that with all new sort of legislation. We see it around the world. But that's why the court did allow the legislator 3 years to really finalize the policy. I mean, if you just read these questions, that is exactly the challenges we're going to sit with. There was a question, and that was one of the main purposes of maternity leave originally, is time to recover from childbirth, which some would say is mother-specific. And then, of course, the challenges of how do you manage cross-employer awarding of these benefits. So I'd like to see how the legislator, I hope they don't use their full 36 months before they do it. But in the meantime, I believe employers need to see what elements are immediately applicable, which changes, and consult with an advisor if you need guidance on that, and make sure that your policies and treatment addresses that.
Yeah. So, Charity, let me ask you, what Lorraine is saying is correct. It's obviously using certain terminology, and obviously due to changes in society and needs, it has brought about this necessity and obviously the decision in the case. Just obviously your personal view, do you think that in terms of definitions and the issues that are raised by Lorraine, do you think there might be any legal recourse where maybe someone approaches the Constitutional Court to make it clearer, or do you think it's purely a legislative process from now onwards?
I think from now onwards, we are dealing with a situation where, because of the general having to have your policies gender neutral, you need to avoid the whole element of discrimination. Having any clauses that speak of how the structure or the categories used to be, and just adding on top of that. So if there is a sense of discrimination, then you do find employees approaching the CCMA, for instance, alleging the discrimination. And if they can show it, and they can show that it's not justified, then there is a legal recourse to it. But I think a lot of, just to add on to that, based on the questions that have been asked, Anthony, is also the element of fear of abuse as well. That employees, or what we're currently seeing with the employers that we are consulting, that they're mostly worried about the fear of abuse. And this is not assuming bad intention, or that employees are trying to game the system, but it's a real issue of flexibility. So the more flexible a leave framework becomes, then the more important it is for HR to put the right controls around it. So from an HR perspective, you would need to be comfortable answering questions like, is the person entitled to the parental leave? How much of the shared entitlement has already been used? Are we approving leave that fits within the total allocation?
Just to add to, sorry.
Sorry, I'll hand it over to you. So the practical, so how we see this practically happening, and it's one of something that Lorraine also touched on, is first we need to look at the fact that we need to look into the parentalhood status and the key dates. So confirming the birth, the adoption, placement, and commissioning arrangements, and how the leave is being shared as well. So it's important to get confirmation on not an informal conversation, but a signed form that records the agreed split and the intended dates as well. And we can put measures, simple controls that make a difference basically within the structure. So, but I'll hand it over to Sue if she would like to add.
Yes, from an HR point of view, that is what I mentioned a little bit earlier, is in terms of the HR pack, what we're going to have is a disclosure. We've already added a disclosure in there, and it's got a section to state this is how much the one partner is taking and this is how much the other partner is taking, and both of them are signing for it. And there's only so much of controls that we can actually put in place without going against other laws like POPIA and stuff like that. So it's a very fine line, and we've got to be very sensitive to what information we ask. But in order to control those splits, the best way would be the disclosure in the parental leave form. And also, when we're asking for the documentation, that's where the medical certificate comes in, your birth certificate comes in. So from an HR point of view, that would be probably what we can ask. One other thing I'd like to just point out is when we are training managers, we need to train them to be sensitive as to how they support employees in this. For example, in South Africa, it is legal for same-sex marriages. So, for example, let me just throw an example out there. You have two males in a situation where they are adopting a child, whatever the case may be. The manager can't go to that employee and say, oh, well, so who's deciding to play the mom and who's deciding to play the dad or whatever? Those are those questions that we need to be sensitive. So yes, we can support our employees, and there's certain things that HR can do to assist the process, but we also need to provide value in terms that we train the managers. This is what you can ask. This is what you can't ask. From an HR point of view, in good faith, we look at what's part of the disclosure. In other words, the employee is like, my wife is taking 2 months, I'm taking 2 months. In an instance, and this will probably go back to charity now, we might, as she said, there's abuse to the system. There could be. We're not saying that there's going to be, but there could be. In that instance, what could happen is, what if somebody comes through and they say, okay, fine, we're going on this leave, and it doesn't happen. Now, this is where charity comes in and we go to misconduct. So employees need to be made aware that, yes, we are looking at this document that you've signed, this disclosure in good faith. Charity, do you want to comment on probably that? Oh, sorry.
So, Sue, sorry, I just wanted to comment on that before Charity comes in. So obviously there's good intent behind the court decision. And obviously we've looked at practicalities, we've looked at challenges. But from an HR point of view, if you look at the operational HR in any organization, the consequence of all of this is possibly be that there's going to be a lot more work, and the onus is going to be on HR to manage this fairness process. Would you agree with that? And can you maybe tell us a little bit of your day-to-day challenges you'd have with that, or expand on it?
Absolutely. It is very challenging for HR. We've already had males go on parental leave. With our clients at BSO HR, we've already had this happen. So we've already managed the process. And so far, it has been very successful with us. So as I said, we provide to our clients a maternity pack where we know we're keeping the employee informed in terms of what information we need from them. And in good faith, we're accepting that. But we're also making it known to them that if in this document, let's just say it's incorrect, the information you're providing and signing to is incorrect, that is amounting to misconduct. So for us to manage it, yes, it is a little bit more work, but we're moving towards gender neutral policies, and it is a benefit to the client. And I'm quite happy of the changes. I really, really am quite happy of the changes, and it's going to take a little bit of extra work, but that's fine. If the child is going to get the best possible care from both parents, and it's in all fairness, then it's worth it.
Charity, you want to add to that?
I think she has touched on quite a lot, but the leave sharing, I'll just add a bit of touch to it, that the leave sharing, I think on the HR side is where we end up being stuck in the middle, because you do, especially where the whole split thing comes into play, that if both parents do not agree, then it needs to be split equally. Does HR now come in as a policing between the two couples to make sure that they split this evenly, which it should not be the case. HR comes in from an administrative purposes, where you inform them that this is the leave that I need to take, and they just administer or they process it. So it becomes complicated because you find situations where, for instance, it's two employers, it's a couple, two employers. The one employer has already approved leave on their side. The other employer still or may still need to be awaiting confirmation on the leave that has been taken, and they have not yet approved. So HR can feel a lot of pressure to sort out these issues, even though it's not its role to resolve these disagreements. So that's what we're currently facing with some of the clients that we are consulting with.
Yes. Yeah. To add to what Charity has said, it actually comes down to like almost resolving a domestic dispute. But when we come to a situation like that, we would split or advise the split 50-50. I just want to make mention of something, that the birthing mother has preference from a medical perspective because of the recovery period. So if there's a medical, let's just say there's risk to the pregnancy, then the birthing mother gets preference to the 4 weeks before and 6 weeks after. And then there's a medical certificate that allows her to go back. So that leave is preferential to her. because of the recovery, because of it's medically necessary. So when we're splitting the leave, we will keep that in mind, of course. She gets first preference in that case, or the birthing mother gets first preference in that case. But worst case scenario, if there is a dispute, then it's going to be 50-50.
So, Sue, I think what also just alluding to something that Charity said is that it's not ultimately HR's responsibility to sort it out between two parties if they're two employers. But the problem is HR is really there to make sure that it works. So what is the consequence of that? Does it mean that there's going to have to be some kind of arbitration process? Are you now going to have to negotiate with other parties, even though it's beyond your mandate? What do you see happening in those cases? Because you need to resolve it.
Resolving it is going to be very challenging, I can tell you that. Remember that the reason that this law came into, is being adjusted is that ladies need help at home, right? So it's like when you have a baby, there's a lot of couples that they live on their own, they live far from grandparents and stuff like that. So when a lady has, let's just say, for example, gone through a cesarean section, she requires almost 3 weeks, and then there's nobody there at home to help her, So we've got to sit with the employee, whether it's the male or the female, and say, oh, well, you need to understand your wife, sit and try and resolve it, but still don't get involved in a domestic dispute. So that is like a fine line between getting into somebody's personal space and just realizing you HR and all you there is an advisory category. So one of the questions we did get is, oh, well, what happens when, for example, the husband decides he wants to take 2 months off to go fishing with his buddies? Now, this is something that's beyond HR's control. There's nothing we can actually do about that. All we can do is advise and suggest, and then on that non-disclosure form, trust and believe in good faith and accept it. Our hands are actually limited to that degree.
No, that's true. I think because there's so many questions, let's start looking at some of the questions, and that will hopefully create some more debate. Sue, I'll ask you the first one. You probably did allude to it, but they say, what will you do about the 6 weeks of the birthing mother needs after the birth of the child? Maybe you can just reinforce what you said earlier.
Yes. So the 6 weeks for the birthing mother is medically required for her to recover. She gets preference on that. Okay. And also, remember, there is 4 weeks before that 6 weeks as well. So that means if, for example, it's a high-risk pregnancy, there's no choice but to give her medically. There's no choice but to give her that. So the father cannot actually use that if medically it is required that she take the rest, because it is for the health of the child, the health of the mother. Anything over and above that, yes, we can split. But let's just say, for example, we do have a situation where medically she can't come back in that 6 weeks. Maybe she needs an extra week or so. From a medical perspective, we have to look at the health of the child and the health of the mother. Yes, the father is there to help out. We do understand that. But we have to look at the overall picture before we consider any decisions.
So there seem to be quite a few questions around this, and maybe we just need to put it into the context of the question. So obviously you've explained the 6 weeks. There's another question that says, am I correct that both parents cannot be off at the same time? And then, of course, it goes on. Sorry, just hold on, Sue. Then it goes on to how do companies control the split of the 4 months? So maybe let's just take it step by step with an example.
Okay, so the leave can be taken concurrently. Oh, and what I want to mention is the leave needs to be taken within the 4 months. So even if there is a split between the parents, it can be taken together, or it can be taken 2 months and 2 months. No problem. That's fine. But it has to be taken within that 4 months, because you can't now have the birthing mother take 2 months and then 6 months down the line decide, oh, well, I need to finish off. I need to take the additional. No, it doesn't work like that. It has to be within that 4-month period. So there is a lot that factors into these decisions. And from an HR point of view, to control that, we just need to educate the employee to say, understand that if you're taking this leave, sometimes both the employees work for the same company and they're losing 2 employees as opposed to 1. And that means now you're operationally preparing for 2 sets of people not to be at work. Maybe it's a small company. It's the smaller companies that are going to probably find it more challenging. But if you look at the law and the way the changes are coming through, we are now accommodating different sets of rules for smaller companies, different sets of rules for the larger companies. Because the smaller companies, to replace people and to train people, it's a little bit more challenging. In terms of like the bigger companies, you can probably distribute work differently. If two people in a company of 10,000 people go off on maternity leave, okay, 2 people in a company with 50 people, there's a bigger impact there.
So what you're saying is it's not one size fits all. You really need to look at the environment and the circumstances when developing the policy.
Absolutely.
Okay. Charity, a question for you. In fact, maybe 2 questions that run into each other and really relate to legal rights. That is, practically, how would you change the policy of maternity to include that of paternity in a company policy? Maybe you can give us an example. And then over and above that, you can maybe just allude to the rights that the employer has to ask for proof from, let's say, the other parent's employer, because now you're talking multi-parties and stakeholders here. Maybe you can deal with those 2 points, Charity.
Okay. I'll touch on your second point first, then I'll go to your first one. I think at the beginning, I did mention that HR, yes, they need to ensure that the process runs smoothly within the company, but they can't necessarily police this process. So HR can at the moment have a standard parental leave sharing form, and it doesn't need to be complicated. So the leave form should state who the parents are, how much leave each parent will take, when the leave will be taken, and a declaration as well that the total leave doesn't exceed the shared entitlement. And you can also include there a default rule that is an upfront default rule where you mention that if no agreement is submitted by a certain date, for instance, then HR applies the equal split and proceeds. So this removes the whole element of HR being a mediator in these instances. And once HR receives that form, then all it needs to do, it's not for them to negotiate, but it's for them to administer. And in terms of contacting the other employer, this is something that HR cannot do outside of the employee's knowledge and consent. So because it would be generally violating the privacy and data protection laws. So they just need to, like Sue touched on, you need to work on a trust basis that what is completed on that form is accurate and true, and you just need to administer it as well.
So Charity, just sorry, to emphasize, what you're saying is that company 1 does not have the right to access information from company 2. So we're really going to be relying on cooperation and honesty, if I can call it that. What if company 1 discovers later that this hasn't panned out and that there has been, let's call it, misuse or abuse of this system? What do you think, or what do you envisage the right of company 1 has?
Then that's as we're stepping into the whole misconduct that Sue touched on, and the whole disciplinary process based on company policies and procedure. We're stepping into that zone now. It's a misconduct, and you need to continue with the whole disciplinary process, the internal disciplinary process.
Okay. All right. So that doesn't change
yes.
the issues. No. Okay. All right, then.
And just to go back to your first, I think there was a first point about how to change the policies. Am I correct?
Yes.
Okay. So in terms of changing the policy, it's not you're not in this moment, you're not tweaking the policy, but it's more of a reset of your policy. So the first step is to collapse all the existing leave categories into one parental leave framework. And that means that the maternity, paternity, adoption, and commissioning leave are no longer separate policies, but they sit under one umbrella. So from there, HR will then need to clearly define the total parental leave that employees are entitled to, explain how it is shared, which is something that we have touched on within this webinar, and remove all the gendered language entirely. And once that is drafted, the next step will then be, my colleague Sue also touched on that, the manager guidance to offer managers just that short explanation that tells them how this works and when to escalate to HR, because without that, then managers do not know how to administer it as well, and employees do not. There also needs to be an element of communication to employees as well, because they need to be aware of what they're entitled to, so that they don't feel that there's more or less on that they are entitled to.
Charity, you mentioned an important point there, and that is that if companies don't address the change in policy, it's going to create a lot of administrative issues, and obviously it'll unsettle the employees. In the extreme case, we've got 3 years before legislation comes in which forces everybody to adhere. What happens if an employer decides not to deal with it, let's say in the next 18 months? What do you think the implications, what are the legal issues there?
I think because now it creates a huge issue here, Anthony, because now with all these webinars happening, with all the information circulating, there's a lot of employees that get to really understand how this policy works. So employers cannot move away from it now. We have participants in this webinar as well that are also employees, and they know that it's something that needs to happen, needed to be implemented immediately. So employers will find, which is one thing that we also experienced with one of our clients, where an employee sends an email to say, I'm about to go, I need to go on parental leave. I do see that your policies have not changed. This is what is required by the Concord. Please administer it correctly. So we will find those requests from employees, and it's very difficult now for employers to ignore it. They need to address it, because now everyone knows of it, and you do find that there will be employees that are challenging it through the CCMA for unfair treatment, unfair discrimination. Those are the type of cases that employers will be facing.
So I think the message is quite clear that the sooner employers get these policies amended, the better. And
yes, definitely. And not when I think it's better to do it sooner and not when you experience your first case and you're trying to figure out how to work around it. It's very good and easier to administer it when you've already started with it now, before you actually get your first case within the company.
Okay. Maybe just to add on to that, Charity, obviously we've determined that it's important to address these policy changes. Is this a negotiation or discussion between various stakeholders, because you've got the employer, you've got the employee? Practically, how would that look in terms of developing these policies?
I think in terms of developing the policies, it would come from the employer side, in terms of having discussion as to what they will be including, especially with the benefits. I think more of it is the benefits and not necessarily what the law states. The law has already said that this needs to be implemented as a minimum. And the discussion is mainly on what they will offer. If there's anything that will be offered above and beyond what the legislation or what the Concord ruling says. So it has to be that discussion from management to decide what they will be including within their policies and what they can read. It's still audible, because I do see that there's a pop-up of internet.
I see it disappeared for me and it came back. So hopefully also saw people giving you hand claps. So I'm assuming that some people did hear it. Yeah.
I'm guessing that they got it. I think with now checking my internet, I lost my train of thought. But just to try and remember where I was directing this, it's a management discussion financially, what they are willing to, whether they are willing to offer any benefits on top of that, and as well filtering it to employees, the communication as well to inform the employees of what has been included within the policy.
Okay, great. Sue, to you, a question, and I know it was an issue when we marketed and sent out invites for this webinar, was really, can you clarify the responsibility between payment for parental leave between the UIF and the employer?
Yes. Okay. So at this point in time, per the law, maternity leave is unpaid. Parental leave still unpaid. So the employer does not need to pay this, and it's now claimed from UIF. However, the UIF systems are not aligned with this law at this point in time. All that's being paid at a UIF level is the code PL, which is for the parental leave. I'm talking about males. For females, yes, they will still be paid. If they take half of the leave, they will still be paid by UIF, but the company does not need to pay. If their company offers a discretionary benefit, that's good and well, but they now also need to remember they need to extend that to males as well. Coming back to, this is also something I think employees, when they're applying for this sort of leave, need to keep in mind. You will be paid for the 10 days. You will need to plan, and babies are very expensive. You will need to plan for the amount of unpaid leave that you're going to get until the systems are all aligned. So it's a matter of, from a financial point of view, how are you planning for your baby? And HR needs to assist you to basically support you with the knowledge that you require for this planning. So all of this comes into play where you're looking at, okay, fine, from a UIF point of view, at this point in time, men will only get paid the 10 days parental leave until the system's aligned. From a point of view of the company, depending if they give a discretionary benefit, do they now want to extend it? They have to extend it, obviously, whatever they're giving to because it's gender neutral. Whatever you're giving to the female, you've got to afford it to the male. Or, and we're still sticking with payment here, do they say, now maybe we need to sit and consult, and maybe we need to reduce these benefits and still give it? So it all comes down to the financial dynamics. What are the variables on both sides? And yeah, it's challenging, but interesting to see how this is going to pan out.
Right, and ultimately it will become the company's policy, which will be determined by management in consultation. Is that right?
Yes, all management has to do and all HR has to do is make sure that the policies that they are implementing or changing are still within the minimum requirements of the law. Yes, we can go above it, but below it, we're having a problem. All of us are sitting at CCMA.
Yeah. And then, Sue, I've got a question here, which I know you love using this scenario. It says, how do we deal with male employees who have taken at least 2 months at a time, but are taking it for the third time in the year? As you said, males could have more than one child in a 9-month period. How would you deal with that in terms of a policy?
Okay. In South Africa, we have, yeah, it is very challenging in South Africa. Our culture is very different. And in terms of what's culturally acceptable in South Africa is different to the different countries. So globally, yes, they're able to accommodate monogamy. In South Africa, we have a situation of, for example, you can have a wife in the farm, you can have a wife, and you know, this is just the way it is. But we have also got to consider things like Ubuntu. It takes a village to raise a child. This is where we come from, you know. This is how it is. So what can we do from a policy point of view? This we can suggest probably a limitation, but that might come across as, well, for my first child, you allowed me to do this, and for my second child, you know. So it's going to be a bit of a juggle at this point in time. If a person wants to go more than once, are they able to do it? And the space time within which maybe HR can consider putting in this benefit is available as a paid benefit every 6 months. But if within a 12-month period you go for a second time, then it won't be a paid benefit. So there's still a lot of wiggle room here. Nothing is clearly defined at the moment. But if a male does come through and say, well, I need to go for the third time, that's somebody probably not at work for the entire year.
Yeah.
It's still something that needs to be seriously thought about.
Yeah, unfortunately, we don't have any precedent. So I imagine it'll evolve over the next 36 months
Yes,
and beyond.
I'm waiting for an adventurous father like this.
Yeah, because I mean, there's so many things to consider: financial, productivity, etc., etc. So we'll just have to wait and see. And I think it probably all comes down to the initial design of the policy. Um, so yeah, a lot of effort's going to have to go into that. Charity, a question for you. One of the questions here is: have polygamous
Polygamous.
marriages been taken into account? So if a husband has two wives, how does that get impacted by this court decision?
I think
In other words,
just to give you a straightforward answer,
go for it.
Anthony, the Constitutional Court only touched on, it didn't specifically address the polygamous marriages. The ruling just said that it
Oops, I think
applies to all parents.
Charity's frozen. Can anybody else hear
Oh,
her?
No, I can see her. Charity?
am I still there? At least we
Yes, you're still
declared
here.
at the start that we're having technical issues, so no one should be surprised. Anthony,
No,
am I
continue.
good on your end? I think we need, if the facilitator is not hearing me, then it creates an issue of did I
I
answer
can
the
hear you
question?
loud and
But I'll
clear.
just okay, thank you very much,
Yeah.
Sue. Just to answer what the question that Anthony asked about polygamous marriages and whether that has been considered, the judgment just touched on the fact that it applies to all parents, biological, adoptive, commissioning categories, but it did not make mention or analyze or create any rules for polygamous or customary polygamous households. So at the moment, it's very interesting to see how that will unfold, but it's not something that the ruling touched on.
So
Thank you.
Charity, essentially what we're doing is we're looking to see how the law is going to give us guidelines on this. There is no guidelines at the moment. Let's understand that there is no guidelines for repeated medical for repeated parental leave. There's no guidelines for it.
Yes.
All we're doing is the best we can do in terms of trying to handle the situation. But what we've handled so far, we haven't had that situation. And when we do have it, I think it's going to be very interesting to see if somebody comes to us every 4 months and goes on parental leave, how are we going to handle that from an operational perspective, and especially from companies that have like a 12-month project, and if you've gone for 8 of that months, and the other thing I want to make mention of is from an incentive perspective. We'd want to know, how does that work with your bonuses, your incentives earned, your targets in terms of your contracts? It brings a lot of challenges for that as well. Where, okay, fine, I'm going to go on maternity leave, but I'm not going to qualify for this. I won't be able to make that target. It depends on, it all comes down to also what's in your contract. It will be clearly explained what is in your contract and what's going to happen. But it now comes down to, how would it work?
I think it will be also interesting to see whether fathers or people have the appetite to take those 2 months when they can only claim for the 10 days. From a financial perspective, it will be interesting to see if there is that appetite to take that extended leave, especially because I did see one of the questions they touched on is if the mother is not working and the father is the one who is working, can they take the full 4 months? Yes, they can, but it's interesting to see whether they do have the appetite to take the full 4 months if their only UIF has not changed or taken into consideration paying out that amount of days that the father would be taking. So it's quite an interesting change, and looking forward to what's happening or what's to come.
Yeah, because when you have a baby, it's all about buying the nappies and buying.
Is back.
Oh, Anthony, you're back. Sorry, Anthony, we were having a conversation without you. We apologize.
No, wonderful. Apologies. We had some technical issues, but I'm back. Not sure where we cut off, but
We were discussing the multiple times that, and a male can take the leave.
Yes.
We're also discussing he needs to now be aware of the financial implications, and it is so important when you have a baby to have money. For now, UIF has not spoken about that. They have not told us anything about whether or not it was going to be paid. It's unpaid for 36 months. So for 36 months, if a male does go, he needs to understand he's only getting paid for 10 days. For now.
Okay, great. Just sorry, go for it, Charity.
No, sorry. You can go ahead. Sorry about that.
Just a question that we've got here, and I don't know if it's employer specific, but the question says, what happens to the 3 days family responsibility leave that is paid? Can this also be taken by both the mom and the dad? Maybe Sue?
I think the family responsibility leave is a separate thing from the parental leave. So that it's a separate entitlement under the BCEA. It doesn't touch on the parental leave. So if you are taking family responsibility and you're meeting the requirements of taking it, then you are entitled to it, but it does not form part of the parental leave.
Just to add to that, when it was just 3 days of family responsibility leave, that was taken to court, and the decision, I think, was made on 1st of January 2020. And that's how the 10 days parental leave came. And then 3rd of October 2025, yes, the men are winning. We've now come to, okay, fine, they can have also 4 months and 10 days. So this is the stages of development.
Sue, just you probably did cover it, but maybe just to answer the question specifically, the question here says, does the male parent qualify for UIF if they are the primary caregiver?
At this point in time, they will only get paid for the 10 days until systems are aligned, UIF systems are aligned, and they tell us, well, we're going to be paying this. But at this point in time, from the 3rd of October, 36 months, it will just be the 10 days.
And that's because the laws have not been amended yet.
Yes, their systems haven't been updated at UIF level.
Okay. And also another very specific question, Sue. We probably covered generally, but to answer it specifically, it says, in the event of the loss of the child at birth, do both parents get the 6 weeks post-birth leave? Or is that a policy allowance?
Okay. So in those situations, the birthing mother again would be given preference because of the medical recovery that is required. So in that instance, it's going to be preference to birthing mother because that is the reason you need that time, is to recuperate. Because whether or not there's a baby present is not the issue. Your body is still going through those same phases. You still need to recover. So in that situation, it would be preference to a birthing mother.
Okay. And also just to clarify specifically, can the dad take the full 4 months if the mother is not working?
Yes, absolutely.
Yeah. We did touch on that when you lost connectivity, and
No problem. Just making sure we cover all the questions.
Yes. I can see Anthony is planning his fishing trip for 4 months and 10 days. I can see this.
I think that stage of my life has passed me. No risk.
No risk on your end.
Yeah. And Charity, maybe just once again, just to specifically confirm, a question here is the implementation date is immediate, or is it immediate as the BCEA has not been updated? So is it immediate, or do we wait the 36 months come into play? Maybe just expand and explain.
So those few guidelines that it is immediate, let me start there. It is immediate as of the 3rd of October 2025. Those guidelines that the Constitutional Court have provided is to close that vacuum because we are still waiting for Parliament to inform us as to how the law will be changing. So it is immediate. Companies need to, or should already have started changing their policies. Yeah, I don't know if there was an extension to the question that I might have missed.
Can I just jump in? Sorry, Anthony, can I just jump in? When we are changing any policy from an HR perspective, and I'm BSO HR, we do outsourcing. So from our perspective, what we're doing for our clients is we're making sure that the policy has been updated immediately, because that's your foundation, right? The other thing is, if you're going to reduce the benefits, it can't just be done. It needs to be done in consultation. So if you're deciding to do something like that as a company, please sit with us and we'll assist you with the process, because it's not something that you can just change without consultation. That is very important. If you want to do the policies, you want it reviewed, or you want us to do it for you, because of the sensitivity of wording, we're available for that too, because we've also done that for our clients.
Maybe just a question for Lorraine. One of the questions here is, if you have contractors, in other words, if you have a contractual arrangement rather than a full-time employment, how would these provisions or change in the law affect those contracts?
Oh, I think he's offline. Yeah, he's offline.
We've lost him. Who wants to answer?
We've lost him. Shame, we have lost him.
Sue, do you want to maybe answer that?
Oh, that's a very interesting one.
That's a very interesting one.
That is a very interesting one. I think we'd have to think a little bit more about that one, because sometimes your contract is a year, and if you're going to be gone for 4 months of that. But still, from a male perspective, that's just going to be 10 days of payment. And you are informing your employer, and you have to go on that leave, and we have to give it to you. Yes, we understand we're going to give it to you. But for 4 months and 10 days, understand that you're only going to get paid for 10 days. Do you want to take that chance financially? That's up to you. Do we as HR have to give you the leave? Yes, we do. Because that's the law. There's nothing we can do about that.
So we've only got a very short while left before we end. Charity, just on that note, wouldn't it also depend on the contract and the terms of the contract?
Yeah. Yes, it would depend on the contract and the terms of that contract. So a lot of these things as well go back to the contract. Whatever we're changing, if it was a contractual benefit, we need to consult. If it's there within the contract, then we need to also make provision for it. So we also need to establish what is there in terms of the contractual relationship between the contractor and the employer.
Okay. So if can you contract, I mean, could a contract exclude the BCA EA minimum requirements?
If you don't make mention of it, you are still governed by it. So you can't avoid it just by not including it within your contract. You are still governed by legislation.
Okay, I think that's obviously an important point when it comes to these contractual relationships. So we've only got a few seconds left. I think I just want to thank everybody, thank the panel, thank everybody who joined us. And please, I think if there's one message that comes out of this, is that it's effective 3rd of October 25. It needs to be addressed, and the sooner the better. We will still attempt to personally respond to any email queries that we haven't dealt with. And certainly, if you have any queries, you're looking for any assistance, please do contact us, any of the panelists or myself or BDO directly, if you need any help. Thank you so much for joining, and enjoy the rest of the day.
Anthony, there's a request to have another webinar once we have received the changes. So we need to confirm that we will be having another webinar.
Absolutely. Look out for notices. We certainly will be planning that. Yeah, absolutely. Thank you so much.
Thank you very much.
Bye-bye.
Thank you, everyone.